Question 1. Which section of CrPC deals with medical examination of a victim of rape? The answer is Section 164A, medical examination of the victim of rape. This is in the form of a revision, so we can go through the section as well. When an offense of rape or its attempt is under investigation and it is proposed to get the person of the woman examined by a medical expert, such examination shall be conducted by a registered medical practitioner with the consent of such woman or of a competent person. It is to be remembered that this provision appears in Section 164A immediately after recording of statement or confessions by a judicial magistrate. This is question 2. Whose prior permission is required under CrPC if a woman is to be arrested after sunset and before sunrise? Provisions relating to arrest are given in Section 46 CrPC. Subsection 4 of Section 46 prohibits arrest of a woman after sunset and before sunrise in normal circumstances. It is permitted only if there are exceptional circumstances, and under these circumstances prior permission will be required, prior permission of judicial magistrate of first class, and this prior permission is to be obtained only by a woman police officer, which means if a woman is to be arrested for whatever offense after sunset and before sunrise, it can be done only by a woman police officer, and it can be done only with prior permission of judicial magistrate first class. Question 3. What is the maximum amount of fine imposable by a magistrate of first class? The limits of sentencing in respect of different courts is given in Section 29. As far as a magistrate of first class is concerned, he can pass sentences with imprisonment of up to 3 years or fine up to 10,000 rupees. It was earlier 5,000, now it has been raised to 10,000 rupees. So please remember, the fine amount is 10,000 rupees and imprisonment is up to 3 years. This is Section 29 subsection 2. This is an important subsection, and we expect questions many a times on this subsection. Question 4. Provisions relating to plea bargaining are contained in which chapter of Criminal Procedure Code? This is a new chapter which was introduced with effect from 2006. That is why the chapter number is being asked. The number is 21A, and we have to write 21 like this. The chapter on plea bargaining came into effect from 5th of July 2006. Question 5. What does in-camera trial mean? Answer is this. In-camera trial is the opposite of trial in open court, where all parties and witnesses testify in a public courtroom. So normal trials take place in an open court, where everyone testifies in a public courtroom. Arguments are also held in a public courtroom. Public generally is allowed in such trials. In camera is a legal term that means in private. It refers to a situation where all spectators and those who are not legally required are excluded from the courtroom. Only the concerned persons will be allowed. In CrPC, the general procedure is given in section 327, which says that every criminal court is an open court. And what is meant by an open court? Open court is a court where the public generally may have access. This is the meaning of a court being an open court. In such a court, public generally will have access. Only limitation is the capacity of the courtroom. This is section 327. And as an exception, we have a provision in subsection 2, which says that inquiry and trials in respect of offences under section 376, punishable under 376, and 376A to 376E of IPC. These are all offences relating to rape. Inquiry and trial of such offences shall be conducted in camera. This provision came into force with effect from 25th of December 1983. So now, as far as CrPC is concerned, all criminal courts are open courts, but inquiry and trials in respect of these specified offences shall be conducted in camera, where public in general shall not be allowed. Question 6. Under section 311A of CrPC, who has the power to order a person to give specimen signature or handwriting? This provision was not there earlier. This provision was inserted in the year 2006. As per this provision, a magistrate of first class is empowered to order any person, including an accused person, to give specimen signatures or handwriting, and the purpose can be for investigation. Under the Evidence Act, we have a provision where the court is empowered to order specimen signatures or handwriting when proceedings are before the court. But as far as proceedings of investigation, proceedings before they reach the court is concerned, there was no such provision earlier. This was introduced with effect from 2006. Now, a judicial magistrate of first class is empowered to order for specimen signatures or handwriting. Question 7. Which section of CrPC specifies compoundable offences? Answer is simple. The section is 320. There are two subsections, 320 subsection 1, 320 subsection 2. Both these subsections contain a list of those offences which can be compounded. Under the first subsection, those offences are listed which can be compounded by specified persons without the intervention of any other authority. Under subsection 2, those offences are listed where compounding can be done by the specified persons, but only with the consent of the court. So that's the only difference between these two subsections. 320 subsection 1, 320 subsection 2. These two provisions contain a list of offences which can be compounded by specified persons.